This audio case is brought to you by Laudio. United States Term Limits versus Thornton, United States Supreme Court, decided 1995. Justice Stevens delivered the opinion of the court. The Constitution sets forth qualifications for membership in the Congress of the United States. Article 1, Section 2, Clause 2, which applies to the House of Representatives, provides, "No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen." Article 1, Section 3, Clause 3, which applies to the Senate, similarly provides, "No person shall be a senator who shall not have attained to the age of 30 years and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen." Today's cases present a challenge to an amendment to the Arkansas State Constitution that prohibits the name of an otherwise eligible candidate for Congress from appearing on the general election ballot if that candidate has already served 3 terms in the House of Representatives or 2 terms in the Senate. The Arkansas Supreme Court held that the amendment violates the federal Constitution. We agree with that holding. Such a state-imposed restriction is contrary to the fundamental principle of our representative democracy embodied in the Constitution, that the people should choose whom they please to govern them. Allowing individual states to adopt their own qualifications for congressional service would be inconsistent with the framers' vision of a uniform national legislature representing the people of the United States. If the qualifications set forth in the text of the Constitution are to be changed, that text must be amended. At the general election on November 3, 1992, the voters of Arkansas adopted Amendment 73 to their state constitution. Proposed as a term limitation amendment, its preamble stated, "The people of Arkansas find and declare that elected officials who remain in office too long become preoccupied with re-election and ignore their duties as representatives of the people. Entrenched incumbency has reduced voter participation and has led to an electoral system that is less free, less competitive, and less representative than the system established by the Founding Fathers. Therefore, the people of Arkansas, exercising their reserved powers herein, limit the terms of elected officials." The limitations in Amendment 73 apply to 3 categories of elected officials. Section 1 provides that no elected official in the executive branch of the state government may serve more than 2 4-year terms. Section 2 applies to the legislative branch of the state government. It provides that no member of the Arkansas House of Representatives may serve more than 3 2-year terms, and no member of the Arkansas Senate may serve more than 2 4-year terms. 3. The provision at issue in these cases applies to the Arkansas Congressional delegation. It provides, "Any person having been elected to 3 or more terms as a member of the United States House of Representatives from Arkansas shall not be certified as a candidate and shall not be eligible to have his or her name placed on the ballot for election to the United States House of Representatives from Arkansas." B. Any person having been elected to 2 or more terms as a member of the United States Senate from Arkansas shall not be certified as a candidate and shall not be eligible to have his or her name placed on the ballot for election to the United States Senate from Arkansas. Amendment 73 states that it is self-executing and shall apply to all persons seeking an election after January 1st, 1993. On November 13, 1992, respondent Bobby Hill, on behalf of herself, similarly situated Arkansas citizens, residents, taxpayers, and registered voters, and the League of Women Voters of Arkansas, filed a complaint in the Circuit Court for Pulaski County, Arkansas, seeking a declaratory judgment that Section 3 of Amendment 73 is unconstitutional and void. Her complaint named as defendants then Governor Clayton, other state officers, the Republican Party of Arkansas, and the Democratic Party of Arkansas. The state of Arkansas, through its Attorney General, Petitioner Winston Bryant, intervened as a party defendant in support of the amendment. Several proponents of the amendment also intervened, including petitioner U.S. Term Limits, Inc. On cross motions for summary judgment, the Circuit Court held that Section 3 of Amendment 73 violated Article 1 of the federal Constitution. With respect to that holding, in a 5-2 decision, the Arkansas Supreme Court affirmed, writing for a plurality of 3 justices, Justice Robert L. Brown concluded that the congressional restrictions in Amendment 73 are unconstitutional because the states have no authority to change, add to, or diminish the requirements for congressional service enumerated in the qualifications clauses. He noted, if there is one watchword for representation of the various states in Congress, it is uniformity. Federal legislators speak to national issues that affect the citizens of every state. The uniformity in qualifications mandated in Article 1 provides the tenor and the fabric for representation in the Congress. Piecemeal restrictions by state would fly in the face of that order. Justice Brown's plurality opinion also rejected the argument that Amendment 73 is merely a ballot access amendment, concluding that the intent and the effect of Amendment 73 are to disqualify congressional incumbents from further service. Justice Brown considered the possibilities that an excluded candidate might run for Congress as a write-in candidate or be appointed to fill a vacancy to be glimmers of opportunity that are faint indeed, so faint in our judgment that they cannot salvage Amendment 73 from constitutional attack. In separate opinions, Justice Gerald P. Brown agreed that Amendment 73 violates the federal Constitution. 2 justices dissented from the federal constitutional holding. Justice Hayes started from the premise that all political authority resides in the people, limited only by those provisions of the federal or state constitutions specifically to the contrary. Because his examination of the text and history of the qualifications clauses convinced him that the Constitution contains no express or implicit restriction on the state's ability to impose additional qualifications on candidates for Congress, Justice Hayes concluded that Section 3 is constitutional. Special Chief Justice Craycraft, drawing a distinction between a measure that imposes an absolute bar on incumbent succession and a measure that merely makes it more difficult for an incumbent to be elected, concluded that Amendment 73 does not even implicate the qualifications clauses, and instead is merely a permissible ballot access restriction. The state of Arkansas, by its Attorney General and the interveners petitioned for writs of certiorari, because of the importance of the issues, we granted both petitions and consolidated the cases for argument. We now affirm. As the opinions of the Arkansas Supreme Court suggest, the constitutionality of Amendment 73 depends critically on the resolution of 2 distinct issues. The first is whether the Constitution forbids states to add to or alter the qualifications specifically enumerated in the Constitution. The second is, if the Constitution does so forbid, whether the fact that Amendment 73 is formulated as a ballot access restriction rather than as an outright disqualification is of constitutional significance. Our resolution of these issues draws upon our prior resolution of a related but distinct issue, whether Congress has the power to add to or alter the qualifications of its members. 26 years ago, in Powell v. McCormick, We review the history and text of the qualifications clauses in a case involving an attempted exclusion of a duly elected member of Congress. The principal issue was whether the power granted to each House in Article 1, Section 5, Clause 1 to judge the qualifications of its own members includes the power to impose qualifications other than those set forth in the text of the Constitution. In an opinion by Chief Justice Warren for 8 members of the court, we held that it does not. Because of the obvious importance of the issue, the court's review of the history and meaning of the relevant constitutional text was especially thorough. We therefore begin our analysis today with a full statement of what we decided in that case. The issue in Powell. In November 1966, Adam Clayton Powell Jr. was elected from a district in New York to serve in the United States House of Representatives for the 90th Congress. Allegations that he had engaged in serious misconduct while serving as a committee chairman during the 89th Congress led to the appointment of a select committee to determine his eligibility to take a seat. That committee found that Powell met the age, citizenship, and residency requirements set forth in Article 1, Section 2, Clause 2. The committee also found, however, that Powell had wrongfully diverted House funds for the use of others and himself, and had made false reports on expenditures of foreign currency. Based on those findings, the House, after debate, adopted House Resolution 278, excluding Powell from membership in the House and declared his seat vacant. Several voters of the district from which he had been elected filed suit seeking a declaratory judgment that the House resolution was invalid because Article 1, Section 2, Clause 2 sets forth the exclusive qualifications for House membership. We ultimately accepted that contention, concluding that the House of Representatives has no authority to exclude any person duly elected by his constituents who meets all the requirements for membership expressly prescribed in the Constitution. In reaching that conclusion, we undertook a detailed historical review to determine the intent of the framers. Though recognizing that the Constitutional Convention debates themselves were inconclusive, we determined that the relevant historical materials reveal that Congress has no power to alter the qualifications in the text of the Constitution. We started our analysis in Powell by examining the British experience with qualifications for membership in Parliament, focusing in particular on the experience of John Wilkes. While serving as a member of Parliament, Wilkes had published an attack on a peace treaty with France. This literary endeavor earned Wilkes a conviction for seditious libel and a 22-month prison sentence. In addition, Parliament declared Wilkes ineligible for membership and ordered him expelled. Despite, or perhaps because of, these difficulties, Wilkes was re-elected several times. Parliament, however, persisted in its refusal to seat him. After several years of Wilkes' efforts, the House of Commons voted to expunge the resolutions that had expelled Wilkes and had declared him ineligible, labeling those prior actions subversive of the rights of the whole body of electors of this kingdom. After reviewing Wilkes' long and bitter struggle for the right of the British electorate to be represented by men of their own choice, we concluded in Powell that on the eve of the Constitutional Convention, English precedent stood for the proposition that the law of the land had regulated the qualifications of members to serve in Parliament, and those qualifications were not occasional but fixed. Against this historical background, we reviewed the conventional debates as manifesting the framers' intent that the qualifications in the Constitution be fixed and exclusive. We found particularly revealing the debate concerning a proposal made by the Committee of Detail that would have given Congress the power to add property qualifications. That such a power would vest an improper and dangerous power in the legislature, by which the legislature can by degrees subvert the Constitution. Madison continued, a republic may be converted into an aristocracy or oligarchy as well by limiting the number capable of being elected as the number authorized to elect. We expressly noted that the parallel between Madison's arguments and those made in Wilkes's behalf is striking. The framers further revealed their concerns about congressional abuse of power when Governor Morris suggested modifying the proposal of the Committee of Detail to grant Congress unfettered power to add qualifications. We noted that Hugh Williamson expressed concern that if a majority of the legislature should happen to be composed of any particular description of men, of lawyers, for example, the future elections might be secure to their own body. We noted, too, that Madison emphasized the British Parliament's attempts to regulate qualifications, and that he observed, the abuse they had made of it was a lesson worthy of our attention. We found significant that the convention rejected both Morris's modification and the committee's proposal. We also recognized in Powell that the post-convention ratification debates confirmed that the framers understood the qualifications in the Constitution to be fixed and unalterable by Congress. For example, we noted that in response to the anti-federalist charge that the new Constitution favored the wealthy and well-born, Alexander Hamilton wrote, "The truth is that there is no method of securing to the rich the preference apprehended but by prescribing qualifications of property, either for those who may elect or be elected. But this forms no part of the power to be conferred upon the national government. The qualifications of the persons who may choose or be chosen, has been remarked upon other occasions, are defined and fixed in the Constitution, and are unalterable by this legislature." We thus attached special significance to Hamilton's express reliance on the immutability of the qualifications set forth in the Constitution. Moreover, we reviewed the debates of the state conventions and found that they also demonstrate the framers' understanding that the qualifications for members of Congress had been fixed in the Constitution. The exercise by Congress of its power to judge the qualifications of its members further confirmed this understanding. We concluded that, during the first 100 years of its existence, Congress strictly limited its power to judge the qualifications of its members to those enumerated in the Constitution. As this elaborate summary reveals, our historical analysis in Powell was both detailed and persuasive. We thus conclude now, as we did in Powell, that history shows that, with respect to Congress, the framers intended the Constitution to establish fixed qualifications, not rely solely on an analysis of the historical evidence, but instead complemented that analysis with an examination of the basic principles of our democratic system. We noted that allowing Congress to impose additional qualifications would violate that fundamental principle of our representative democracy, that the people should choose whom they please to govern them. Our opinion made clear that this broad principle incorporated at least two fundamental ideas. First, we emphasized the egalitarian concept that the opportunity to be elected was open to all. We noted in particular Madison's statement in the Federalist that under these reasonable limitations enumerated in the Constitution, the door of this part of the federal government is open to merit of every description, whether native or adoptive, whether young or old, and without regard to poverty or wealth, or to any particular profession of religious faith. Similarly, we noted that Wilson Carey Nicholas defended the Constitution against the charge that it violated democratic principles by arguing, "It has never been considered a great security to liberty that very few should be excluded from the right to be chosen to the legislature. This Constitution has amply attended to this idea. We find no qualifications required except those of age and residence." Second, we recognize the critical postulate
that sovereignty is vested in the people, and that sovereignty confers on the people the right to choose freely their representatives to the national government. For example, we noted that Robert Livingston endorsed the same fundamental principle. The people are the best judges who ought to represent them. To dictate and control them, to tell them whom they shall not elect, is to abridge their natural rights. Similarly, we observed that before the New York Convention, Hamilton emphasized, "The true principle of a republic is, that the people should choose whom they please to govern them. Representation is imperfect in proportion, as the current of popular favor is checked." This great source of free government, popular election, should be perfectly pure, and the most unbounded liberty allowed. Quoting from the statement made in 1807 by the chairman of the House Committee on Elections, we noted that restrictions upon the people to choose their own representatives must be limited to those absolutely necessary for the safety of the society. Thus, in Powell, we agreed with the sentiment expressed on behalf of Wilkes's mission to Parliament, that the right of the electors to be represented by men of their own choice was so essential for the preservation of all their other rights that it ought to be considered as one of the most sacred parts of our Constitution. Powell thus establishes two important propositions. First, that the relevant historical materials compel the conclusion that, at least with respect to qualifications imposed by Congress, the framers intended the qualifications listed in the Constitution to be exclusive, and second, that the conclusion is equally compelled by an understanding of the fundamental principle of our representative democracy, that the people should choose whom they please to govern them. Petitioners argue, somewhat half-heartedly, that the narrow holding in Powell, which involved the power of the House to exclude a member pursuant to Article 1, Section 5, does not control the more general question whether Congress has the power to add qualifications. Powell, however, is not susceptible to such a narrow reading. Our conclusion that Congress may not alter or add to the qualifications in the Constitution was integral to our analysis and outcome. Only 2 terms ago, we confirmed this understanding of Powell in Nixon v. United States, after noting that the 3 qualifications for membership specified in Article 1, Section 2 are of a precise, limited nature and unalterable by the legislature. We explained, our conclusion in Powell was based on the fixed meaning of qualifications set forth in Article 1, Section 2. The claim by the House that its power to be the judge of the elections, returns, and qualifications of its own members was a textual commitment of unreviewable authority was defeated by the existence of this separate provision specifying the only qualifications which might be imposed for House membership. Unsurprisingly, the state courts and lower federal courts have similarly concluded that Powell conclusively resolved the issue whether Congress has the power to impose additional qualifications. In sum, after examining Powell's historical analysis and its articulation of the best principles of our democratic system, we reaffirm that the qualifications for service in Congress set forth in the text of the Constitution are fixed, at least in the sense that they may not be supplanted by Congress. Our reaffirmation of Powell does not necessarily resolve the specific questions presented in these cases. For petitioners argue that whatever the constitutionality of additional qualifications for membership imposed by Congress, the historical and textual materials discussed in Powell do not support the conclusion that the Constitution prohibits additional qualifications imposed by states. In the absence of such a constitutional prohibition, petitioners argue the 10th Amendment and the principle of reserved powers require that states be allowed to add such qualifications. Before addressing these arguments, we find it appropriate to take note of the striking unanimity among the courts that have considered the issue. None of the overwhelming array of brief submitted by the parties and amici has called to our attention even a single case in which a state court or federal court has approved of a state's addition of qualifications for a member of Congress. To the contrary, an impressive number of courts have determined that states lack the authority to add qualifications. Courts have struck down state-imposed qualifications in the form of term limits, district residency requirements, loyalty oath requirements, and restrictions on those convicted of felonies. Prior to Powell, the commentators were similarly unanimous. This impressive and uniform body of judicial decisions and learned commentary indicates that the obstacles confronting petitioners are formidable indeed. That the Constitution contains no express prohibition against state-added qualifications, and that Amendment 73 is therefore an appropriate exercise of a state's reserved power to place additional restrictions on the choices that its own voters may make. We disagree for two independent reasons. First, we conclude that the power to add qualifications is not within the original powers of the states and thus is not reserved to the states by the 10th Amendment. Second, even if states possessed some original power in this area, we conclude that the framers intended the Constitution to be the exclusive source of qualifications for members of Congress, and that the framers thereby divested states of any power to add qualifications. The plan of the convention, as illuminated by the historical materials, our opinions, and the text of the 10th Amendment, draws a basic distinction between the powers of the newly created federal government and the powers retained by the pre-existing sovereign states. As Chief Justice Marshall explained, it was neither necessary nor proper to define the powers retained by the states. These powers proceed not from the people of America, but from the people of the several states, and remain after the adoption of the Constitution what they were before, except so far as they may be abridged by that instrument. This classic statement by the Chief Justice endorsed Hamilton's reasoning in the Federalist No. 32 that the plan of the Constitutional Convention did not contemplate an entire consolidation of the states into one complete national sovereignty, which the state governments would clearly retain all the rights of sovereignty which they had before, and which were not, by that act, exclusively delegated to the United States. The text of the 10th Amendment unambiguously confirms this principle. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. As we have frequently noted, the states unquestionably do retain a significant measure of sovereign authority. They do so, however, only to the extent that the Constitution has not divested them of their original powers and transferred those powers to the federal government. Contrary to petitioners' assertions, the power to add qualifications is not part of the original powers of sovereignty that the 10th Amendment reserved to the states. Petitioners' 10th Amendment argument misconceives the nature of the right at issue because the amendment could only reserve that which existed before. As Justice Story recognized, the states can exercise no powers whatsoever which exclusively spring out of the existence of the national government, which the Constitution does not delegate to them. It can say that it has reserved what it never possessed. Justice Story's position thus echoes that of Chief Justice Marshall in McCulloch v. Maryland. In McCulloch, the court rejected the argument that the Constitution's silence on the subject of state power to tax corporations chartered by Congress implies that the states have reserved power to tax such federal instrumentalities. As Chief Justice Marshall pointed out, an original right to tax such federal entities never existed, and the question whether it has been surrendered cannot arise. In language that presaged Justice Story's argument, Chief Justice Marshall concluded, "This opinion does not deprive the states of any resources which they originally possessed." With respect to setting qualifications for service in Congress, no such right existed before the Constitution was ratified. The contrary argument overlooks the revolutionary character of the government that the framers conceived. Prior to the adoption of the Constitution, the states had joined together under the Articles of Confederation. In that system, the states retained most of their sovereignty, like independent nations bound together only by treaties. After the Constitutional Convention convened, the framers were presented with and eventually adopted a variation of a plan not merely to amend the Articles of Confederation, but to create an entirely new national government with a national executive, national judiciary, and a national legislature. In adopting that plan, the framers envisioned a uniform national system, rejecting the notion that the nation was a collection of states and instead creating a direct link between the national government and the people of the United States. In that national government, representatives owe primary allegiance not to the people of a state, but to the people of the nation. As Justice Story observed, each member of Congress is an officer of the Union, deriving his powers and qualifications from the Constitution, and neither created by, depended upon, nor controllable by the states. Those officers owe their existence and functions to the united voice of the whole, not of a portion of the people. Representatives and senators are as much officers of the entire Union as is the President. States thus have just as much right, and no more, to prescribe new qualifications for a representative as they have for a president. It is no original prerogative of state power to appoint a representative, a senator, or president for the Union. We believe that the Constitution reflects the framers' general agreement with the approach later articulated by Justice Story. For example, Article 1, Section 5, Clause 1 provides, "Each House shall be the judge of the elections, returns, and qualifications of its own members." The text of the Constitution thus gives the representatives of all the people the final say in judging the qualifications of the representatives of any one state. For this reason, the dissent falters when it says that the people of Georgia have no say over whom the people of Massachusetts select to represent them in Congress. Two other sections of the Constitution further support our view of the framers' vision. First, consistent with Story's view, the Constitution provides that the salaries of representatives should be ascertained by law and paid out of the Treasury of the United States, which is Article 1, Section 6, rather than by individual states. The salary provisions reflect the view that representatives owe their allegiance to the people and not to the states. Second, the provisions governing elections reveal the framers' understanding that powers over the election of federal officers had to be delegated to, rather than reserved by, the states. It is surely no coincidence that the context of federal elections provides one of the few areas in which the Constitution expressly requires action by the states, namely, that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. This duty parallels the duty under Article 2, that each state shall appoint in such manner as the legislature thereof may direct a number of electors. These clauses are express delegations of power to the states to act with respect to federal elections. This conclusion is consistent with our previous recognition that, in certain limited contexts, the power to regulate the incidence of the federal system is not a reserved power of the states, but rather is delegated by the Constitution. Thus, we have noted that while in a loose sense the right to vote for representatives in Congress is sometimes spoken of as a right derived from the states, this statement is true only in the sense that the states are authorized by the Constitution to legislate on the subject as provided by Section 2 of Article 1. In short, as the framers recognized, electing representatives to the national legislature was a new right, arising from the Constitution itself. The 10th Amendment thus provides no basis for concluding that the states possess reserved power to add qualifications to those that are fixed in the Constitution. Instead, any state power to set the qualifications for membership in Congress must derive not from the reserved powers of state sovereignty, but rather from the delegated powers of national sovereignty. In the absence of any constitutional delegation to the states of power to add qualifications to those enumerated in the Constitution, such a power does not exist. States possess, as part of their original powers, some control over congressional qualifications. The text and structure of the Constitution, the relevant historical materials, and most importantly, the basic principles of our democratic system all demonstrate that the qualifications clauses were intended to preclude the states from exercising any such power and to fix as exclusive the qualifications in the Constitution. Much of the historical analysis was undertaken by the court in Powell. There is, however, additional historical evidence that pertains directly to the power of the states. That evidence, though perhaps not as extensive as that reviewed in Powell, leads unavoidably to the conclusion that the states lack the power to add qualifications. The available affirmative evidence indicates the framers' intent that states have no role in the setting of qualifications. In Federalist Paper number 52, dealing with the House of Representatives, Madison addressed the qualifications of the electors and the elected. The Federalist number 52 at 325, Madison first noted the difficulty in achieving uniformity in the qualifications for electors, which resulted in the framers' decision to require only that the qualifications for federal electors be the same as those for state electors. Madison argued that such a decision must be satisfactory to every state because it is conformable to the standard already established, or which may be established by the state itself. Madison then explicitly contrasted the state control over the qualifications of electors with the lack of state control over the qualifications of the elected. The qualifications of the elected being less carefully and properly defined by the state constitutions and being at the same time more susceptible of uniformity, have been very properly considered and regulated by the Convention. A representative of the United States must be of the age of 25 years, must have been 7 years a citizen of the United States, must at the time of his election be an inhabitant of the state he is to represent, and during the time of his service must be in no office under the United States. Under these reasonable limitations, the door of this part of the federal government is open to the merit of every description, whether native or adoptive, whether young or old, and without regard to poverty or wealth, or to any particular profession of religious faith. Madison emphasized this same idea in the Federalist number 57. Who are to be the objects of popular choice? Every citizen whose merit may recommend him to the esteem and confidence of his country. No qualification of wealth, of birth, of religious faith, or of civil profession is permitted to fetter the judgment or disappoint the inclination of the people. The provisions in the Constitution governing federal elections confirm the framers' intent that states lack power to add qualifications. The framers feared that the diverse interests of the states would undermine the national legislature, and thus they adopted provisions intended to minimize the possibility of state interference with federal elections. For example, to prevent discrimination against federal electors, the framers required in Article 1, Section 2, Clause 1, that the qualifications for federal electors be the same as those for state electors. As Madison noted, allowing states to differentiate between the qualifications for state and federal electors would have rendered too dependent on the state government that branch of the federal government which ought to be dependent on the people alone. Similarly, in Article 1, Section 4, Clause 1, though giving the states the freedom to regulate the times, places, and manner of holding elections, the framers created a safeguard against state abuse by giving Congress the power to, by law, make or alter such regulations. The convention debates make clear that the framers' overriding concern was the potential for states' abuse of the power to set the times, places, and manner of elections. Madison noted that it was impossible to foresee all the abuses that might be made of the discretionary power. Governor Morris feared that the states might make false returns and then make no provisions for new elections. When Charles Pinckney and John Rutledge moved to strike the Congressional safeguard, the motion was soundly defeated. As Hamilton later noted, nothing can be more evident than that an exclusive power of regulating elections for the national government in the hands of the state legislatures would leave the existence of the Union entirely at their mercy. The framers' discussion of the salary of representatives reveals similar concerns. When the issue was first raised, Madison argued that congressional compensation should be fixed in the Constitution rather than left to state legislatures because otherwise it would create an improper dependence. George Mason agreed, noting that the parsimony of the states might reduce the provisions so low that the question would be not who were most fit to be chosen, but who were most willing to serve. When the issue was later reopened, Nathaniel Gorham stated that he wished not to refer the matter to the state legislatures, who were always paring down salaries in such a manner as to keep out of offices men most capable of executing the functions of them. Edmund Randolph agreed that if the states were to pay the members of the national legislature, a dependence would be created that would vitiate the whole system. Rufus King urged the danger of creating a dependence on the states, and Hamilton noted that those who pay are the masters of those who are paid. The convention ultimately agreed to vest in Congress the power to set its own compensation. In light of the framers' evident concern that states would try to undermine the national government, they could not have intended states to have the power to set qualifications. Indeed, one of the more anomalous consequences of petitioner's argument is that it accepts federal supremacy over the procedural aspects of determining the times, places, and manner of elections, while allowing the states carte blanche with respect to the substantive qualifications for membership in Congress. The dissent nevertheless contends that the framers' distrust of the states with respect to elections does not preclude the people of the states from adopting eligibility requirements to help narrow their own choices. As the dissent concedes, however, the framers were unquestionably concerned that the states would simply not hold elections for federal officers, and therefore the framers gave Congress the power to make or alter state election regulations. Yet under the dissent's approach, the states could achieve exactly the same result by simply setting qualifications for federal office sufficiently high that no one could meet those qualifications. In our view, it is inconceivable that the framers would provide a specific constitutional provision to ensure that federal elections would be held while at the same time allowing states to render those elections meaningless by simply ensuring that no candidate would be qualified for office. Given the framers' wariness over the potential for state abuse, we must conclude that the specification of fixed qualifications in the constitutional text was intended to prescribe uniform rules that would preclude modification by either Congress or the states. We find further evidence of the framers' intent in Article 1, Section 5, Clause 1, which provides each House shall be the judge of the elections, returns, and qualifications of its own members. That Article 1, Section 5 vests a federal tribunal with ultimate authority to judge a member's qualifications is fully consistent with the understanding that those qualifications are fixed in the federal Constitution, but not with the understanding that they can be altered by the states. If the states had the right to prescribe additional qualifications, such as property, educational, or professional qualifications, for their own representatives, state law would provide the standard for judging a member's eligibility. As we concluded in Murdoch v. Memphis, federal questions are generally answered finally by federal tribunals, because rights which depend on federal law should be the same everywhere, and their construction should be uniform. The judging of questions concerning rights which depend on state law is not, however, normally assigned to federal tribunals. The Constitution's provision for each House to be the judge of its own qualifications thus provides further evidence that the framers believed that the primary source of those qualifications would be federal law. We also find compelling the complete absence in the ratification debates of any assertion that states had the power to add qualifications. In those debates, the question whether to require term limits or rotation was a major source of controversy. The draft of the Constitution that was submitted for ratification contained no provision for rotation, and arguments that echoed in the preamble to Arkansas's Amendment 73, opponents of ratification condemned the absence of a rotation requirement, noting that there is no doubt that senators will hold their office perpetually, and in this situation, they must of necessity lose their dependence and their attachment to the people. Even proponents of ratification expressed concern about the abandonment in every instance of the necessity of rotation in office. At several ratification conventions, participants proposed amendments that would have required rotation. The Federalist responses to those criticisms and proposals addressed the merits of the issue, arguing that rotation was incompatible with the people's right to choose. As we noted above, Robert Livingston argued, the people are the best judges who ought to represent them. To dictate and control them, to tell them whom they shall not elect, is to abridge their natural rights. This rotation is an absurd species of ostracism. Similarly, Hamilton argued that the representatives' need for re-election rather than mandatory rotation was the more effective way to keep representatives responsive to the people, because when a man knows he must quit his station, let his merit be what it may, he will turn his attention chiefly to his own emolument. Regardless of which side has the better of the debate over rotation, it is most striking that nowhere in the extensive ratification debates have we found any statement by either a proponent or an opponent of rotation that the draft Constitution would permit states to require rotation for the representatives of their own citizens. If the participants in the debate had believed the states retained the authority to impose term limits, it is inconceivable that the Federalists would not have made this obvious response to the arguments of the pro-rotation forces. The absence in any otherwise freewheeling debate of any suggestion that states have the power to impose additional qualifications unquestionably reflects the framers' common understanding that states lacked that power. In short, if it had been assumed that states could add additional qualifications, that assumption would have provided the basis for a powerful rebuttal to the arguments being advanced. The failure of intelligent and experienced advocates to utilize this argument must reflect a general agreement that its premise was unsound, and that the power to add qualifications was one that the Constitution denied the states. Congress's subsequent experience with state-imposed qualifications provides further evidence of the general consensus on the lack of state power in this area. In Powell, we examined that experience and noted that during the first 100 years of its existence, Congress strictly limited its power to judge the qualifications of its members to those enumerated in the Constitution. Congress first confronted the issue in 1807 when it faced a challenge to the qualifications of William McCreary, a representative from Maryland who allegedly did not satisfy a residency requirement imposed by that state. In recommending that McCreary be seated, the report of the House Committee on Elections noted, the committee proceeded to examine the Constitution with relation to the case submitted to them and find the qualifications of members are therein determined, without reserving any authority to the state legislatures to change, add to, or diminish those qualifications, and that, by that instrument, Congress is constituted the sole judge of the qualifications prescribed by it, and are obliged to decide agreeably to the constitutional rules. The chairman of the House Committee on Elections elaborated during debate. The Committee of Elections considered the qualifications of members who have been unalterably determined by the Federal Convention, unless changed by an authority equal to that which framed the Constitution at first, that neither the state nor the federal legislatures are vested with authority to add to those qualifications, so as to change them. As we noted in Powell, the congressional debate over the committee's recommendation tended to focus on the narrow issue of the power of the states to add to the standing qualifications set forth in the Constitution. The whole House, however, did not vote on the committee's report, and instead voted only on a simple resolution, resolved that William McCreary is entitled to his seat in this House. Though the House debate may be inconclusive, commentators at the time apparently viewed the seating of McCreary as confirmation of the state's lack of power to add qualifications. For example, in a letter written to Joseph Cable, Thomas Jefferson noted the argument that to add new qualifications to those of the Constitution would be as much an alteration as to detract from them. He then added, and so I think the House of Representatives of Congress decided in some case. I believe that of a member from Baltimore. Similarly, for over 150 years prior to Powell, commentators viewed the seating of McCreary as an expression of the view of the House that states could not add to the qualifications established in the Constitution. Thus, for example, referring to the McCreary debates, one commentator noted, by the decision in this case, and that in another contested election, it seems to have been settled that the states have not a right to require qualifications for members different from or in addition to those prescribed by the Constitution. Other commentators viewed the incident similarly. Finally, it is clear that in Powell, we view the seating of McCreary as the House's acknowledgement that the qualifications in the Constitution were fixed. The Senate experience with state-imposed qualifications further supports our conclusions. In 1887, for example, the Senate seated Charles Faulkner of West Virginia, despite the fact that a provision of the West Virginia Constitution purported to render him ineligible to serve. The Senate Committee on Privileges and Elections unanimously concluded that no state can prescribe any qualification to the office of United States Senator in addition to those declared in the Constitution of the United States. The Senate Committee on Rules and Administration reached the same conclusion in 1964 when faced with the challenge to Pierre Salinger, who had been appointed to serve as senator from California. We recognize, as we did in Powell, that congressional practice has been erratic and that the precedential value of congressional exclusion cases is quite limited. Nevertheless, those incidents lend support to the result we reach today. Our conclusion that states lack the power to impose qualifications vindicates the same fundamental principle of our representative democracy that we recognize in Powell, namely that the people should choose whom they please to govern them. As we noted earlier, the Powell Court recognized that an egalitarian ideal, that election to the national legislature should be open to all people of merit, provided a critical foundation for the constitutional structure. This egalitarian theme echoes throughout the constitutional debates. In the Federalist No. 57, for example, Madison wrote, "Who are to be the objects of popular choice? Every citizen whose merit may recommend him to the esteem and confidence of his country. No qualification of wealth or of birth, of religious faith, or of civil profession is permitted to fetter the judgment or disappoint the inclination of the people." Similarly, hoping to persuade voters in New York that the Constitution should be ratified, John Stevens, Jr. wrote, "No government that has ever yet existed in the world affords so ample a field to individuals of all ranks for the display of political talents and abilities. Real merit, let a situation be what it will, need despair." And Timothy Pickering noted that, while several of the state constitutions prescribe certain degrees of property as indispensable qualifications for offices, this which is proposed for the U.S. throws the door wide open for the entrance of every man who enjoys the confidence of his fellow citizens. Additional qualifications pose the same obstacle to open elections, whatever their source. The egalitarian ideal, so valued by the framers, is thus compromised to the same degree by additional qualifications imposed by states as those by Congress. Similarly, we believe that state-imposed qualifications, as much as congressionally imposed qualifications, would undermine the second critical idea recognized in Powell, that an aspect of sovereignty is the right of the people to vote for whom they wish. Again, the source of the qualification is of little moment in assessing the qualification's restrictive impact. Finally, state-imposed restrictions, unlike the congressionally imposed restrictions at issue in Powell, violate a third idea central to this basic principle. that the right to choose representatives belongs not to the states but to the people. From the start, the framers recognized that the great and radical voice of the Articles of Confederation was the principle of legislation for states or governments in their corporate or collective capacities, and as contradistinguished from the individuals of whom they consist. Thus, the framers, and perhaps their most important contribution, conceived of a federal government directly responsible to the people, possessed of direct power over the people, and chosen directly not by states, but by the people. The framers implemented this ideal most clearly in the provision extant from the beginning of the Republic that calls for the members of the House of Representatives to be chosen every second year by the people of the several states. Following the adoption of the 17th Amendment in 1913, this ideal was extended to elections for the Senate. The Congress of the United States, therefore, is not a confederation of nations in which separate sovereigns are represented by appointed delegates, but is instead a body composed of representatives of the people. As Chief Justice John Marshall observed, the government of the Union, then, is emphatically and truly a government of the people. In form and in substance, it emanates from them. Its powers are granted by them, and are to be exercised directly on them and for their benefit. Ours is a government of the people, by the people, for the people. The framers deemed this principle critical when they discussed qualifications. For example, during the debates on residency requirements, Morris noted that in the House, the people at large, not the states, are represented. Similarly, George Read noted that the framers were forming a national government and such regulation would correspond little with the idea that we were one people. James Wilson enforced the same consideration. Consistent with these views, the constitutional structure provides for a uniform salary to be paid from the national treasury, allows the states but a limited role in federal elections, and maintains strict checks on state interference with the federal election process. The Constitution also provides that the qualifications of the representatives of each state will be judged by the representatives of the entire nation. The Constitution thus creates a uniform national body representing the interests of a single people. Permitting individual states to formulate diverse qualifications for their representatives would result in a patchwork of state qualifications, undermining the uniformity and the national character that the framers envisioned and sought to ensure. Such a patchwork would also sever the direct link that the framers found so critical between the national government and the people of the United States. Petitioners attempt to overcome this formidable array of evidence against the state's power to impose qualifications by arguing that the practice of the states immediately after the adoption of the Constitution demonstrates their understanding that they possess such power. One may properly question the extent to which the state's own practice is a reliable indicator of the contours of restrictions that the Constitution imposed on states, especially when no court has ever upheld a state-imposed qualification of any sort. But petitioner's argument is unpersuasive even on its own terms. At the time of the convention, almost all the state constitutions required members of their legislatures to possess considerable property. Despite this near uniformity, only one state, Virginia, placed similar restrictions on members of Congress, requiring that a representative be, inter alia, a freeholder. Just 15 years after imposing a property qualification, Virginia replaced that requirement with a provision requiring that representatives be only qualified according to the Constitution of the United States. Moreover, several states, including New Hampshire, Georgia, Delaware, and South Carolina, revised their constitutions at around the same time as the federal Constitution. In the revised constitutions, each state retained property qualifications for its own state elected officials, yet placed no property qualification on its congressional representatives. The contemporaneous state practice with respect to term limits is similar. At the time of the convention, states widely supported term limits in at least some circumstances. The Articles of Confederation contained a provision for term limits. As we have noted, some members of the convention had sought to impose term limits for members of Congress. In addition, many states imposed term limits on state officers. 4 placed limits on delegates to the Continental Congress, and several states voiced support for term limits for members of Congress. Despite this widespread support, no state sought to impose any term limits on its own federal representatives. Thus, a proper assessment of contemporaneous state practice provides further persuasive evidence of a general understanding that the qualifications in the Constitution were unalterable by the states. In sum, the available historical and textual evidence, read in light of the basic principles of democracy underlying the Constitution and recognized by this court in Powell, reveal the framers' intent that neither Congress nor the states should possess the power to supplant the exclusive qualifications set forth in the text of the Constitution. Petitioners argue that, even if states may not add qualifications, Amendment 73 is constitutional because it is not such a qualification and because Amendment 73 is a permissible exercise of state power to regulate the times, places, and manner of holding elections. We reject those contentions. Unlike Sections 1 and 2 of Amendment 73, which create absolute bars to service for long-term incumbents running for state office, Section 3 merely provides that certain senators and representatives shall not be certified as candidates and shall not have their names appear on the ballot. They may run as write-in candidates, and if elected, they may serve. Petitioners contend that only a legal bar to service creates an impermissible qualification, and that Amendment 73 is therefore consistent with the Constitution. Petitioners support the restrictive definition of qualifications with language from Storer v. Brown, in which we face a constitutional challenge to provisions of the California Elections Code that regulated the procedures by which both independent candidates and candidates affiliated with qualified political parties could obtain ballot position in general elections. The code required candidates affiliated with a qualified party to win a primary election and required independents to make timely filing of nomination papers signed by at least 5% of the entire vote cast in the last general election. The code also denied ballot position to independents who had voted in the most recent primary election or who had registered their affiliation with a qualified party during the previous year. In Storer, we rejected the argument that the challenged procedures created additional qualifications as wholly without merit. We noted that petitioners would not have been disqualified had they been nominated at a party primary or by an adequately supported independent petition and then elected at the general election. We concluded that the California Code no more establishes an additional requirement for the office of representative than the requirement that the candidate win the primary to secure a place on the general ballot or otherwise demonstrate substantial community support. Petitioners maintain that, under Storer, Amendment 73 is not a qualification. We need not decide whether petitioners' narrow understanding of qualifications is correct because, even if it is, Amendment 73 may not stand. As we have often noted, constitutional rights would be of little value if they could be directly denied. The Constitution nullifies sophisticated as well as simple-minded modes of infringing on constitutional protections. In our view, Amendment 73 is an indirect attempt to accomplish what the Constitution prohibits Arkansas from accomplishing directly. As the plurality opinion of the Arkansas Supreme Court recognized, Amendment 73 is an effort to address eligibility to stand for Congress and ballot access clothing, because the intent and the effect of Amendment 73 are to disqualify congressional incumbents from further service. We must, of course, accept the state court's view of the purpose of its own law. We are thus authoritatively informed that the sole purpose of Section 3 of Amendment 73 was to attempt to achieve a result that is forbidden by the federal Constitution. Indeed, it cannot be seriously contended that the intent behind Amendment 73 is other than to prevent the election of incumbents. The preamble of Amendment 73 states explicitly, "The people of Arkansas herein limit the terms of elected officials. Sections 1 and 2 create absolute limits on the number of terms that may be served. There is no hint that Section 3 was intended to have any other purpose. Petitioners do, however, contest the Arkansas Supreme Court's conclusion that the amendment has the same practical effect as an absolute bar. They argue that the possibility of a write-in campaign creates a real possibility for victory, especially for an entrenched incumbent. One may reasonably question the merits of that contention. Indeed, we are advised by the state court that there is nothing more than a faint glimmer of possibility that excluded candidate will win. Our prior cases, too, have suggested that write-in candidates have only a slight chance of victory. But even if petitioners are correct that incumbents may occasionally win re-election as write-in candidates, there is no denying that the ballot restrictions will make it significantly more difficult for the barred candidate to win the election. In our view, an amendment with the avowed purpose and obvious effect of evading the requirements of the qualifications clauses by handicapping a class of candidates cannot stand. To argue otherwise is to suggest that the framers spent significant time and energy in debating and crafting clauses that could be easily evaded. More importantly, allowing states to evade the qualifications clauses by dressing eligibility to stand for Congress in ballot access clothing trivializes the basic principles of our democracy that underlie those clauses. Petitioners' argument treats the qualifications clauses not as the embodiment of a grand principle, but rather as empty formalism. It is inconceivable that guarantees embedded in the Constitution of the United States may thus be manipulated out of existence. Petitioners make the related argument that Amendment 73 merely regulates the manner of elections, and that the amendment is therefore a permissible exercise of state power under Article 1, Section 4, Clause 1, the Elections Clause, to regulate the times, places, and manner of elections. We cannot agree. A necessary consequence of petitioners' argument is that Congress itself would have the power to make or alter a measure such as Amendment 73. That the framers would have approved of such a result is unfathomable. As our decision in Powell and our discussion above make clear, the framers were particularly concerned that a grant to Congress of the authority to set its own qualifications would lead inevitably to congressional self-aggrandizement and the upsetting of the delicate constitutional balance. Petitioners would have us believe, however, that even as the framers carefully circumscribed congressional power to set qualifications, they intended to allow Congress to achieve the same result by simply formulating the election as a ballot access restriction under the Elections Clause. We refuse to adopt an interpretation of the Elections Clause that would so cavalierly disregard what the framers intended to be a fundamental constitutional safeguard. Moreover, petitioners' broad construction of the Elections Clause is fundamentally inconsistent with the framers' view of that clause. The framers intended the Elections Clause to grant states authority to create procedural regulations, not to provide states with license to exclude classes of candidates from federal office. During the convention debates, for example, Madison illustrated the procedural focus of the Elections Clause by noting that it covered whether the electors should vote by ballot or via voce, should assemble at this place or that place, should be divided into districts or all meet at one place, should all vote for all the representatives or all in a district vote for a number allotted to the district. Similarly, during the ratification debates, proponents of the Constitution noted, the power over the manner only enables them to determine how these electors shall elect, whether by ballot, or by vote, or by any other way. Hamilton made a similar point in the Federalist No. 60, in which he defended the Constitution's grant to Congress of the power to override state regulations. Hamilton expressly distinguished the broad power to set qualifications from the limited authority under the Elections Clause, noting that there is no method of securing to the rich the preference apprehended but by prescribing qualifications of property, either for those who may elect or be elected. but this forms no part of the power to be conferred upon the national government. Its authority would be expressly restricted to the regulation of the times, the places, and the manner of elections. As Hamilton's statement suggests, the framers understood the Elections Clause as a grant of authority to issue procedural regulations, and not as a source of power to dictate electoral outcomes, to favor or disfavor a class of candidates, or to evade important constitutional restraints. Our cases interpreting state power under the Elections Clause reflect the same understanding. The Elections Clause gives states authority to enact the numerous requirements as to procedure and safeguards, which experience shows are necessary in order to enforce the fundamental right involved. However, the power to regulate the time, place, and manner of elections does not justify, without more, the infringement of fundamental rights. States are thus entitled to adopt generally applicable and even-handed restrictions that protect the integrity and reliability of the electoral process itself. For example, in Storer v. Brown, the case on which petitioners place principal reliance, we upheld the validity of certain provisions of the California Election Code. In so doing, we emphasized the state's interest in having orderly, fair, and honest elections rather than chaos. We also recognized the state's strong interest in maintaining the integrity of the political process by preventing inter-party raiding, and explained that the specific requirements applicable to independents were expressive of a general state policy aimed at maintaining the integrity of the various routes to the ballot. In other cases, we have approved the state's interest in avoiding voter confusion, ballot overcrowding, or the presence of frivolous candidacies, in seeking to assure that elections are operated equitably and efficiently, and in guarding against irregularity and error in the tabulation of votes. In short, we have approved of state regulations designed to ensure that elections are fair and honest and that some sort of order, rather than chaos, accompanies the democratic processes. The provisions at issue in Storer and our other elections clauses cases were thus constitutional because they regulated election procedures and did not even arguably impose any substantive qualification rendering a class of potential candidates ineligible for ballot position. They served the state interest in protecting the integrity and regularity of the election process, an interest independent of any attempt to evade the constitutional prohibition against the imposition of additional qualifications for service in Congress. And they did not involve measures that exclude candidates from the ballot without reference to the candidate's support in the electoral process. Our cases upholding state regulations of the election procedures thus provide little support for the contention that a state-imposed ballot access restriction is constitutional when it is undertaken for the twin goals of disadvantaging a certain class of candidates and evading the dictates of the qualifications clauses. We do not understand the dissent to contest our primary thesis, namely that if the qualifications for Congress are fixed in the Constitution, then a state-passed measure with the avowed purpose of imposing directly such an additional qualification violates the Constitution. The dissent instead raises two objections, challenging the assertion that the Arkansas Amendment has the likely effect of creating a qualification, and suggesting that the true intent of Amendment 73 was not to evade the qualifications clause, but rather to simply level the playing field. Neither of these objections has merit. As to the first, it is simply irrelevant to our holding today. As we note above, our prior cases strongly suggest that write-in candidates would have only a slim chance of success, and the Arkansas plurality agreed. However, we expressly do not rest on this court's prior observations regarding write-in candidates. Instead, we hold that a state amendment is unconstitutional when it has the likely effect of handicapping a class of candidates and has the sole purpose of creating additional qualifications indirectly. Thus, the dissent's discussion of the evidence concerning the possibility that a popular incumbent will win a write-in election is simply beside the point. As to the second argument, we find wholly unpersuasive the dissent's suggestion that Amendment 73 was designed merely to level the playing field. As we have noted, it is obvious that the sole purpose of Amendment 73 was to limit the terms of elected officials, both state and federal, and that Amendment 73, therefore, may not stand. The merits of term limits, or rotation, have been the subject of debate since the formation of our Constitution, when the framers unanimously rejected a proposal to add such limits to the Constitution. The cogent arguments on both sides of the question that were articulated during the process of ratification largely retain their force today. Over half the states have adopted measures that impose such limits on some offices, either directly or indirectly, and the nation as a whole, notably by constitutional amendment, has imposed a limit on the number of terms that the president may serve. Term limits, like any other qualification for office, unquestionably restrict the ability of voters to vote for whom they wish. On the other hand, such limits may provide for the infusion of fresh ideas and new perspectives, and may decrease the likelihood that representatives will lose touch with their constituents. It is not our province to resolve this long-standing debate. We are, however, firmly convinced that allowing the several states to adopt term limits for congressional service would effect a fundamental change in the constitutional framework. Any such change must come not by legislation adopted either by Congress or by an individual state, but rather, as have other important changes in the electoral process, through the amendment procedure set forth in Article 5. The framers decided that the qualifications for service in the Congress of the United States be fixed in the Constitution and be uniform throughout the nation. That decision reflects the framers' understanding that members of Congress are chosen by separate constituencies, but that they become, when elected, servants of the people of the United States. They are not merely delegates appointed by separate sovereign states. They occupy offices that are integral and essential components of a single national government. In the absence of a properly passed constitutional amendment allowing individual states to craft their own qualifications for Congress would thus erode the structure envisioned by the framers, a structure that was designed, in the words of the preamble to our Constitution, to form a more perfect union. The judgment is affirmed. It is so ordered.
For more audio cases, check out our website, audioforlisteners.com. Follow us on Facebook and Instagram, and subscribe to our YouTube channel.